Hello everyone and welcome to the webinar. I'm just my colleague is just letting participants in at the moment, so we'll just give it a minute, and once the numbers have kind of stabilised, we'll get going with the webinar. I think that's everyone who's sitting in the waiting room before 2 o'clock in the webinar now. So for those of you who don't know me, my name is Lindsay Chalmers. I'm the Development Manager at Community Land Scotland. We are the membership network for aspiring and post-purchase community landowners. And we've been running a series of events on different subjects over the last year, of which this is one. And like our other events, we'll be recording the session today and it will be up on our Vimeo account in the next few days. So if you're a big fan of Ownerless Land and you want to watch it again, or you want to share it with someone else, you'll be able to find it there. And you can also find our whole library of webinars on our Vimeo site if you just Google Vimeo and Community Land Scotland. So the reason we wanted to do a webinar on Ownerless Land was that we are getting an increasing number of inquiries from communities who are really interested in this subject. And for those of you, who've been through the process of taking ownerless land into community ownership, they know that it's quite a complex process. So we thought it'd be really useful today to hear from a couple of community voices who've been through that process, as well as hearing from a couple of agencies who have supported communities going through the process. So today we have lined up as our speakers, Murray Ferguson from Culduthel Woods. Culduthel Woods have actually written up on the Scottish Land Commission's website as a case study, if you want to find out more, but Murray will give us an overview today. We also have Alison MacGillivray from South Islay Development, who's our local development officer. We'll be talking about land that they have just very recently brought into community ownership. We'll also be hearing from James MacKessack-Leitch from the Scottish Land Commission about some of the research they've been doing looking at this issue. And finally, we'll have Paul Harrington, who's a development manager at Highlands and Islands Enterprise, who supported both of the communities who are talking today through that process. Just in terms of housekeeping, we're going to run through all the presentations first, and then we'll have a panel discussion about ownerless land. We're asking everyone if they can keep your questions and answers to the end. It's absolutely fine if you want to type in any Q&A as people are speaking, but we won't respond to them until the end. If you can type your questions into the Q&A box rather than the chat box, it just makes it easier for us if all the questions are in one place. And if there's anyone you want to particularly direct them to, just write that in the box and I will be taking on the job of directing questions to people. If you want to ask a question of everyone, that's fine, we can do that too. So that's a quick run through of how today will run. I'm going to hand over now to our first speaker, Murray Ferguson from Culduthel Community Woods. Thank you, Murray.
Hi, good afternoon, everybody, and thanks very much for the invitation to speak. Can you all hear me okay?
That's good. Yes.
That's perfect, thanks. I thought I'd just tell the story in 3 versions, really. I'll tell you the quick overview version, and then I'll tell you again, going into a bit more detail about some of the issues we had at the key stages, and then I'll try and tell you a few of the things that we think we learned. First of all, a little bit about the woods. There was a picture on the invitation to the meeting. Fantastic area of woods covered in beech and oak and elm, about 6.5 hectares in size, very well used because they're right next to a big secondary school. Up until about 2018, the community was coming forward with all sorts of problems in the woods. They were generally neglected. Trees were falling over, fences falling over, lots of litter, etc. I seem to hear about these at first hand, not least because my wife's the chair of the community council, so this was an issue that was frequently mentioned at home. And then in February 2018, we had a big open community meeting. That led in time to the formation of a steering group, which led in time to the formation of a charity. And that group agreed to conduct some land ownership research, because there was lots of confusion about who owned the land, and lots of stories in the community about who that might be. We decided to go through the process of claiming the land, and right now we're effectively still in that process. So Alison's beating us to it. Our land, unfortunately, is still ownerless, but we do have our prescriptive claimants application in at the moment with the Registers of Scotland, and we hope in a few months the land will be ours. We've got insurance for the land at the moment, and we would have been conducting volunteer events, but obviously with COVID, that's a bit difficult. And you can find out more about this on our website. I think if you Google Culduthel Woods, you should find it fairly easily. I should say we're Culduthel Woods in Inverness. It's a part of the Inverness area. So the second version of the story, I think there was a key stage getting started. And thankfully at that stage, the Community Council applied to the Highland Council for money, and we got £5,000 of money from Highland Council to help get the group started. And that was really important, that leadership was there right at the start to give us as local citizens the confidence that this is worth working on because there's some money in the bank. Second bit of the story is, how did the land become ownerless? And that is an interesting story in itself, because what effectively happened is that a building company owned the land and built houses on as much of it as they possibly could in the 1990s, obviously complying with planning permission. But they quite deliberately held the woods in a separate holding company. And then once all the houses were built, they dissolved that company. Now that happened in 2002. And it wasn't really until 2013-14 that the Queens and Lords Treasurer's Remembrancer, that I'm sure other people will be referring to later on, became involved and started writing to the Highland Council and to the Community Council to say, we've got this area of land that we're holding on behalf of the Crown, would you like to have it? But Highland Council, for obvious reasons, didn't want to take it on because they've got more than enough land to look after already, and the Community Council couldn't own the land. So what happened then was that QLTR disclaimed the land in July 2014. And as I said, it was then a further period of 4 or 5 years before the problems in the wood became so bad that the community became motivated to do something about it. So really, by the time our initiative got involved, the land had been technically ownerless for 4 years, and it had been completely unmanaged, sitting with QLTR effectively for probably a period of 16 years. So quite a period of time had elapsed. The third stage I wanted to talk about was about how did we make the decision to own the land. And as a new steering group, as a new charity, that was quite a big decision. Many of the people sitting around the table were extremely nervous about taking on liabilities. How were we going to raise the funds? Why should we have to do this? Couldn't somebody else do this? So we had to go through quite a few meetings talking about that again and again. Obviously, people were concerned about liabilities and visitor liabilities for visitors, and we had to go through quite a long process of reassuring people about that. And then when we did our tree survey, to our horror, we found that there was about £20,000 worth of work to be done almost immediately on dangerous trees to make the wood safe. And this was
It's Murray frozen for everybody. In that case, doesn't look like Murray's coming back. What I might do is ask Alison if you could give your presentation, and then hopefully Murray can come back and finish his presentation after you. Is that okay, Alison? Are you happy to do that?
Hopefully this is.
I can see and hear you, Alison.
Okay, is that okay? Perfect. Hello, thank you for having us here today. Yeah, it's been a long process here, and I thought I would do a wee bit of a background to Portel and Plainfields and where it all started. And it really is it is a long road. I wanted to write Long Road to Recover, full title for the community, because it has been a long and winding, bumpy road, I would say, I think, for us. Oh, sorry, my keyboard's frozen. So yeah, Bertell Plainfields originally was acquired in 1952 by a bunch of local trustees and called the Bertell Plainfields Association. It was bought from a local landowner, Colin Campbell. So had been in community ownership for over 60 years. And when Sid started working with the local association, it was already alluded to be in full community ownership. The land comprises of over 16 acres. It says on the edge of Bertell, but actually with the new developments of housing and businesses around it, is actually now becoming more of the centre of the village rather than being on the edge of the village. It comprises of various sporting facilities. It's got a football pitch, a tennis court, bowling green, putting, play park, and pitch and putt, as well as the old pavilion building that you can see in this picture. So it was very well established, and it was broadly looked after very well to the best of the ability of the association. Over the last 60 years, the association were finding it harder to maintain, to look after the mass acre of grass, to fund the maintenance, to fund the facilities, and to encourage the local users to keep using it. So they were starting to find it a little bit of a struggle, and obviously the upkeep of the building as well. So in December 2017, the association, the group of committee that was looking after it at that point, came to South Isla Development, and we'd worked for months prior to that to discuss options and to look at how we could help them to bring the community back into the land, to improve the maintenance and help them get some improvement in the tennis courts and bring the aspirations of the community back to life. It became quite a struggle at one point when the committee found it hard to go for funding because they didn't have the charity status that they required for funding. So at an AGM meeting, it was decided, the community decided to sign over the Bertell Plainfields under the umbrella of SID on behalf of the community, and the community were very much in favour of this, to allow us to help that committee move forward and inject some new funding and life and bring the aspirations of the community back into the forefront. So our main first tackle was really to prove the ownership. Obviously, when we transferred over the title, the charity that was Bertell Plainfields disbanded, and as it disbanded, it became evident that they didn't actually have the evidence in their hands to prove that ownership at the community actually owned it, which became a long struggle. I think we spent nearly probably 9 months to a year just trying to find some proof. As you can see on the screen there, a lot of the community had really good articles over the 60 years. They could provide us lots of articles of who was in trustees, when they were trustees, when it was given over. But all of this, when we looked at it, actually we couldn't find a copy of the deeds to say that actually the community owned it. Eventually, we managed to find, after numerous emails with the Register of Scotland searches, that we found in the filing cabinet at Sassons. It was a hard copy that hadn't been updated through the years, so it was still sitting in a filing cabinet, basically in a corner somewhere. So once we found that, we thought all our issues were solved. So we thought, yep, we've got the golden ticket, let's move forward. It then brought up a new dilemma for us. It turned out that actually the tennis courts, which has always been said to be community owned, actually wasn't in the copy title deed for the Plainfields. So it gave us a new angle that we had to find proof of the tennis courts as well. It wasn't just the actual Plainfields itself. We had to prove titleship of the tennis courts, which actually so far we are struggling to do, and we've had to separate that in the actual bid that we move forward to with the Plainfields. So at the moment we have a tennis court that's sitting there as ownerless land, which has been always part of the community, and and seen as community, but we're still unable to prove that at the moment. So hopefully the community can still help us get forward with that, because at the moment Register of Scotland cannot find anything on that at the moment. So as we move through, we found the title deeds, which we thought was our golden ticket. We moved forward with the solicitors to change the title and get it into South Islay name so that we could move forward with our funding applications, which all seemed so simple logically, but it turned out to be a wee bit of an unforeseen problem, because when we solicitors looked at disposition of the transfer, it turned out that it hadn't. Through the years, the association had changed from the original trustees, well, president and vice president in 1952, that through the years the association had changed its articles, it changed its constitution, and therefore when it was transferred over to SED, still wasn't sitting with the same constitution. So it was deemed that it was not viable for the officers who were in-house at that time, who transferred the charity over to SED, to actually transfer the title. So it became another search to find viable persons to be able to sign the title over to SED. It was a very disappointing time, actually, and a very sad time, because a lot of the trustees who were part of the original association had not that long passed away, and their families were all still here and very much aware of it, but were not able to actually transfer it on their behalf. So it became then that the solicitors advised us that the land had become bona vacantia, and that by default the land had become ownerless, because we couldn't prove titleship. We could prove the titleship, but we couldn't transfer the titleship. So by default it was becoming ownerless land, which then was going to be held by the QLTR. So we were advised by our solicitors that the only way to keep this in community ownership, and the only way for SID to move forward with all the aspirations of the community, was for us to start talks with the QLTR to bring it back into community ownership. So this all started and kind of finalised in March 2019 as well. So it started the months-long chat with the QLTR to look at how we could transfer this over into community ownership. We did look at the prescriptive title, and we looked at how that would work. We looked at how that would work with our funders, how that would work with the community, and it was then advised the prescriptive title maybe wasn't the most suitable option for us to go down, and that the QLTR advised SID to purchase the land directly. This was a wee bit of a challenge, because we had to persuade the QLTR that we had the money to buy the land. We had to persuade them to actually go into a legal agreement with us that we weren't going to back out of this, because they didn't want to take on land that they could be left with at the end. So SID then had to carry out an independent valuation of the land to then take this to the QLTR. The evaluation of the land came back at 110,000, which is quite remarkable considering the community bought it in 1952 for £500. So it was a bit of a shock to the community that when originally buying it for £500, we had to look at purchasing this now for £110,000 from the QLTR just to get it back in community ownership. It was a bit of a shock for the board for having to do this. So SID automatically, we submitted our stage 1. We were successful at stage 1 and invited back to put in our stage 2 into the Scottish Land Fund to bring it back into full title. This was a long shot. We were very aware that this was a massive long shot because of the experience and I suppose the history of how it come to be ownerless land. We had to prove that we had the credentials to take this forward and continue it to be in community land, and prove why we needed this to stay in community land and for the recreational purposes of the land. on that one. So we were thankfully in last year in May, June, we were successful in our stage 2, which was a massive relief to be able to get our stage 2 funding. And we thought, again, this was our second golden ticket to keep moving. And we thought we're one step closer. We just have to transfer the deeds and now we are complete. That took a lot longer than we anticipated. So I'm just going to quickly, I'll talk through some of the highlights over the process here. So the process of the transfer of the title was relatively simple. When we spoke to the solicitors, it seemed very simple. We were asked to obviously prove our title. We confirmed the disposition of the land. It was a matter of signing the contracts between the QLTR and then obviously changing title over to us. It was all seemed very simple on paper and didn't seem like it should take a lot of time on paper either. But it was a long process, and as I said there, it's a very steep learning curve, not only for the board, but for us as staff. We had to become a little bit like solicitors ourselves. We had to start learning the lingo. The communication was a challenge, and I think it was consistent. You had to be consistent with your communication and be able to constantly ask questions. I think that was one of the things that I struggled with a little bit, was understanding a lot of the legal jargon, and you had to kind of decode it, I suppose, in one sense, for me to understand, and then decode it so that we could pass that on to the community and the board. Our ever expanding budget was a massive challenge, I won't lie. The budget we got in for our Scottish Land Fund, we had estimated, and we've got quotes for obviously the land purchase, we got quotes with solicitors, and we didn't only have just to pay our solicitors, we had to pay the QLTR solicitors as well. So it was an estimated budget that we had at the start, which rapidly started increasing. I think due to the scale of the project, I don't think it was anticipated at the start that the process was going to be so complicated. I think in paperwork it looked so simple, and I think once the lawyer started to get into the detail of the transfer with the QLTR and then understanding the process of how that goes, the budget started to increase significantly for us in our legal fees, and the time frame started to increase as well. I think that was the one thing that was probably most frustrating for us as staff, was the time frame kept increasing consistently. So it meant we were battling against trying to complete the titleship in time for funding applications that we had lined up, but we weren't able to match that because the time frame kept increasing, and not entirely all because of COVID. I think it was the expectancies of transferring from one office to another office between the QLTR and then having to go to London as well. So I think with the funding solutions, we had to be very creative. I think with COVID hitting, when it did, some of our funding solutions that we had we hoped to have in place, then we redirected their money towards COVID response that we were looking at. So it meant that our funding bid was actually, we were under £10,000 than what we anticipated a month before COVID hit. So SID had to look very carefully at their budget and then look at other solutions for filling that budget gap, because we could see the increasing legal fees every time we spoke and every quarterly budget. And as I mentioned, the time scales consistently were forever lapsing. I think it took in total there, it took over a year to get from having the money to buy the land to having the land signed over on Friday the 19th of March. It was about a year in total before we had it all signed over. And actually at that point, 19th of March, we were pushing it really at that point. We used all our tactics, all our networking systems, every community organisation out there, from High, Community Land Scotland to DTAS, Scottish Land Fund. We were pulling everybody together to help us put a little bit of pressure on our solicitors to get this done, because we just secured Scottish Government money. We needed to be able to own the land to carry forward with the new aspirations and new community hub building, but we couldn't do that without full titleship and proof of ownership. We were consistently up against it. as I mentioned, COVID did have a massive effect on how the timescales, and I think that massively affected the QLTR on how they managed to process their information, because having to go from Scotland to London to sign paperwork, that affected a lot of the processes, and everybody working from home affected that as well. I know, as I mentioned earlier, it did affect how our budget transformed, because unusual income wasn't there and our usual funding streams weren't there. So we had to be very creative on how we managed to pull all our funding streams together for that. What have we learned? I think one of the strong points I think that kept us going as a board and as a staff was believing in our community's aspirations. I think we had to remember why we were doing it and what our outcome was, what our best outcome was for the project. We kept talking and we kept telling our story, and I think that networking really was proved to be the benefit of the project. The talking and telling people how things were going, keeping them up to date on how the project was going or how the project was not going, and where we were stalling, and keeping everybody in the loop was a massive key to getting this complete. And I think one of the other things that I learned was not to be afraid to ask the questions. If I didn't understand something, ask, because I think especially our solicitors sometimes assumed that we understood everything they were telling us, but we didn't always understand what all the things were. And I think your hard work and perseverance will pay off eventually. I think money will come eventually. You just have to keep going and keep persevering. And I think one of the, as I said above, is the building the strong relationships, not just within your community and using them, but also within the funding community, within your support network of DTAS and HIE and all these people out there, because that was one of the things that kept us going through all this, was knowing that we had the support and the communication there from them to give us that advice to keep us going, because that was invaluable through the whole project from the start to the end for us. And I suppose it's one of the things is find the silver lining. Find that silver lining. It's there. There's always, even in the hardest times, there's a silver lining, and this is our silver lining. Is that now we can move forward and move upwards with it. We're consistently listening to our community's feedback. We have their aspirations, their concerns, and a desire to engage in the future generation of playing fields. And this is what it was all for. This is why we were pursuing that title deed, to bring this new community hub into fruition for the community, to bring them back together into the playing fields, to get them to engage in activities that are there now, and to engage new activities into that 16-acre land that they care so much about. So at the moment we are progressing through stage 4 of our plans, and the detail is going to be finalised over the next 4 to 6 months. We're developing the strong desire to keep the space green, which is something the community is very passionate about, and the SID board are very passionate about as well. And that's the key element within the whole playing fields ethos. We will continue to work closely with all the professionals as we work through this and find a way to meet the aspirations of the community, the requirements of the local planning office, and also the outcomes of the funders as well. I think I always felt the hard work, getting a proving title was the hard work, but actually the hard work, it is not starting, it's continuing. I would say we're consistently always working hard at getting everything to move. So I think we are excited, and I say it really is an understatement. We are excited, but we are also ready for the continuation of hard work that comes with full title, which is great. That's me.
Thanks, Alison. That's great. I think where you are now is a real testament to the hard work and determination of you and your board over the last couple of years. I'm sure there'll be lots of questions for you from talking through the complexity of that process you went through. But I'm going to invite Murray back on now, because I can see he has reappeared. So Murray, do you want to finish your presentation?
Yes, thanks. Sorry about that. I don't know what happened. My screen suddenly went blank. I think it was just an outage in the whole house. I think I was talking about demonstrating that there was community support for what we wanted to do. And of course, that's a common feature to many of the sorts of projects we're working on. So the fifth stage of the process I just wanted to talk about in a bit more detail was once we knew the land was ownership and once we knew we wanted to acquire it on behalf of the community, there was a few key things that happened. First of all, we had to appoint lawyers, and we're very blessed to be working with a Murchison Law from Inverness, who've been absolutely fantastic to work with. Also, that the work was financed by Highlands and Islands Enterprise. Thanks, Paul, for all the help you gave us with that. We did look at options before we decided to go down the prescriptive claimants route, which is what we used. So we did look at whether it was possible to go back to Tullochs, because they still exist in the local area as a firm, to see whether or not they could resurrect the company that they had dissolved back in 2002. But so much time had elapsed that really that wasn't a very fruitful way forward. We just couldn't do that. We also had discussions with QLTR to see whether it would be possible to get them to reverse their decision, which they'd made in 2014 to disclaim the land. We explored with them whether that was possible to reverse that decision, but no, it wasn't. There wasn't a legal route to do that. So that meant that we had to go down the prescriptive claimants route, which our lawyers described at the time as being a challenging route. And I think it has so proved to be. It just seems to have taken quite a long time. And I think we've been surprised at how much even our very expert lawyers have had so much uncertainty about what level of information to provide and when. So we've just completed the process where we have completed 1 year by demonstrating our possession of the land, which was open, peaceable, and without judicial interruption, as is required by the law. And we have just submitted our prescriptive claimants application, which took the form of a 7-page legal letter and lots of annexes demonstrating all the work we've done over the last few years. So assuming that goes well, we hope that within a few months we will get a provisional set of deeds, which we will then hold for a period of 10 years, and they'll be perfectly satisfactory for everything we want to do before they're finally legally confirmed. So lastly, third version of the story, what did we learn from all of this? And I'm really struck at how many parallels there are with what Alison was just saying. First of all, the whole concept of ownerless land, and well, in fact, who owns what land in general, is so poorly understood. And we were really struck by, even once we got our heads around what we were talking about, we spoke to quite well qualified and knowledgeable people who sometimes denied that there was such a thing as ownerless land and queried whether what we had found was correct. So the whole concept, I think even having this seminar is a big step forward, and just raising the profile that there is such a thing as ownerless land. And people talk a lot about derelict and vacant land, but not nearly so much about ownerless land. The other thing that really struck us, and I should say I work with the planning system in the Cairngorms National Park, but I'm doing this in a completely personal capacity. But the second thing that struck us was the importance of the planning process, because at the time the houses were built, this really should have been taken care of. And I'm very confident that in Highland Council area, and certainly in the Cairngorms, this would be taken care of now. The houses should have been allowed to be built, and the land should have been either given to the community or provision made for the land to be in community ownership or sympathetic management at that time. And it never needed to get into a situation where it was left ownerless. The third thing that really we learned is that the process to acquire the land really needs to be much simpler. For a community body to have to navigate such complex language, such complex guidance, satisfy the information requirements, have to raise so much public support, and still have lack of clarity even over the timetables for when we're going to get an answer. Our lawyer said that when they submitted the information to Registers of Scotland, there was really no guarantee. It may take 2 months, it may take 6 months, it may take a year. They didn't know how long it would take. So it really a plea to, if possible, try and make it simpler. Fourth thing, I think, is a point about the QLTR disclaiming process, which happened in 2004. I saw this was raised in the report that I'm sure James will refer to, the Land Commission report on vacant and derelict land. But it was really, I think, poorly understood by the community at that time that if they didn't take on the land, and neither did Highland Council, I don't think anybody really explained to them what would happen and that the land would then be left ownerless. It certainly wasn't locally advertised. And there doesn't seem to be a very good link through to the Registers of Scotland land ownership process, or indeed to the Register of Vacant and Derelict Land. So even though it had formally been declared ownerless, you still had to go to quite a lot of trouble to find that out, and that seems surprising. And the last thing I would point out is, just a pointer, I know a lot of work is going on about the future Scottish Land Fund at the moment, and I think we were told at one point that we could have been helped more had there been an owner of the land. The Scottish Land Fund would have been able to help us in a way that they weren't able to help us because the land was ownerless. And again, that seems like a procedural quirk that I'm sure could be corrected. I have to say that Highlands and Islands Enterprise did step into the breach at that point and helped us very, very considerably. We haven't got a valuation of the land. It's something we've been discussing with Paul and High recently, but effectively we're going to be acquiring an asset that's, we think, quite valuable. And really the relatively small sums of money, we're talking about 5, 10, 15,000 pounds of public money, has been, we hope, pretty well spent in terms of, that's just for the legal cost of doing the process. It's not for acquiring the capital value of the land. And lastly, I think we've learned how hard work this is to do this from a community perspective, and that won't be a surprise to anybody on the call. It's been particularly good for me personally to see it from the community end of the telescope rather than from the public body end of the telescope. And lastly, just a huge thanks to several people who I know are on the call who've helped us along the way. Thank you.
Thanks, Mary. Another really interesting insight into the process. I think the two examples we've had there are the two kind of classic examples where a company has dissolved, resulting in land becoming ownerless, and where you've had a trust which is no longer functioning. I think most of the calls we get at Community Land Scotland fall into one of those two categories. So I'm going to hand over to James MacKessack-Leitch from Land Commission now, who has been looking at this issue, and I'm hoping can maybe give us some insights into the big picture.
Yep, thanks, Lindsay. I will try and do that. There's, I think, as we've picked up, there's definitely a lot of kind of complicated things going on. From a policy perspective, though, this makes this a very interesting area to work in. Of course, that usually means it's very difficult for people who are just trying to get on with their lives to work in. But I thought I'd start with some myth busting, and I think this is something that Murray picked up that kind of pervades a lot of thinking at the moment, is can land really be ownerless? And the answer is yes, it can, and it's probably quite a lot more common than people think. There are odd patches probably all over the place that don't have owners that could be put to better and more productive use. And the second question that follows that is, but isn't all land ultimately owned by the government or the Crown? And this changed in Scotland, particularly with the abolition of Feudal Tenure Act in 2000. But at a more fundamental level, Scotland never really fully feudalised to the same extent as England did, and then subsequently Wales and Ireland following their history. So in a way, we have a very different system at a very, very fundamental and a very historical level. But that ownerless land does exist, and actually it's pretty much up for grabs for anyone who can find it and work their way through the process, which I think, as we've seen, is a very long and potentially very risky one as well. So there are two main routes to land becoming ownerless. Largely, there's the element around people dying without heirs. That's fairly well covered. And a lot of the assets that are left behind are quite valuable, so make it back onto the open market through the QLTR in their function. But as in Alison's case, talking about trusteeships, those are some things that the QLTR doesn't inherit. Although trustees exercise rights of ownership over pieces of land, they are not the owners themselves, and therefore those rights don't transfer. So if trusts are not wound up correctly, if trustees you kind of die out or move away without passing that trust on to the next generation, then that does cause problems further down the line. And that's something that we've seen an increasing amount of at the Land Commission as well. The other main route for land becoming ownerless is through defunct companies, whether that's voluntary dissolution in the terms of house builders that Murray's been talking about, or whether that's companies being liquidated, the valuable assets being sold off, and then the liquidators just leaving the less valuable or the things that they think aren't marketable behind. And the other element is statutory strike-off. So where companies fail to live up to their duties, for example, providing 3 years of accounts to Companies House, that type of thing, they can be struck off. And that essentially makes their property become ownerless because the company ceased to exist. Although companies can, of course, be resurrected, as Murray touched upon, but that's not always the case. The owners of the companies often choose not to do that. So where might ownerless land be? Well, there probably is quite a bit of it. Vacant and derelict land and buildings are an obvious place to look for ownerless property, particularly when it's kind of industrial or corporate in nature. Green space and housing developments is something that we're coming across quite a lot. So particularly in the last kind of 30 plus years, where we've had kind of mass market house building by big private developers, they're very keen, obviously, to master plan, and they put green space in and play parks and all those sorts of things. They're not so keen to manage them in the long term. And if the council or someone else doesn't pick them up, then you potentially end up with a Culduthel Woods type of situation where you have amenity ground that's great in the first year, but after 10 years, when no one's been maintaining it, it starts to cause problems. In between large landholders, so particularly in rural Scotland, where you have potentially large land holdings that have been within the same family for generations, their boundaries may not be very clearly defined because they may be Saysine records. And there are often gaps, particularly where those types of land holdings come up against each other, simply because of errors in recording or discrepancies within recording through history. Former industrial sites, particularly in rural areas where they're less obvious, are often ownerless. Urban woodland, overgrown parkland as well, might not necessarily belong to a local authority, but they've maybe been maintaining it while they had the funds to do so. That's less likely in the current environment. And around transport infrastructure, so many areas that had some industry that built their own branch lines, so particularly coal mining in Ayrshire, for example, where there is old railway infrastructure that connects to the main lines, but was never actually nationalised and taken under kind of National British Rail and then into its successor in Railtrack. So that type of infrastructure there may well be ownerless. So there's a whole different range of land that's potentially there. So determining ownerlessness is the next stage, or the first stage, and the key thing is really local knowledge. I mean, that is one of the easiest and most accessible forms of determining whether people have owned it, whether those people are still around, or what the fate of them are and what the land is. And similarly, local authorities often have quite good records and some institutional knowledge about particular sites as well, particularly if they are vacant and derelict sites where they might have been dealing with environmental health problems or antisocial behaviour or other issues. They may know if there's an owner or not already. If none of that leads anywhere, there is Registers of Scotland, be there through Scotland, which lists the main land registration system since 1981, or the Register of Saysines, which dates back to the 17th century. Although you will get a record and it will tell you who the owner is, those titles are correct at the time of registration only, and they're not updated. So if you find a patch of land that looks like it might be ownerless, and one of the cases that we dealt with was ex-railway land, the title belonged to the Skye and Dingwall Railway Company, but the Skye and Dingwall Railway Company was taken over in 1867. So, the land registration system that we're dealing with at the moment really isn't up to date. So you can certainly get a title, whether it's particularly helpful or not is a different question. The Community Ownership Support Service, they have a legal advisor who can provide some help and guidance on how the system works and where you might be able to find evidence. And then there are people like professional searchers. So if anyone's familiar with the daytime TV program Air Hunters, there are similar types of people in Scotland whose job it is to trace owners of various assets or potential owners. And then finally, there's the QLTR, who are essentially the ultimate arbiter of whether land is ownerless or not. And before you get to the QLTR, you really do need to go through all those other steps and really figure out if there is a very good case for this piece of land in particular being ownerless. So the QLTR itself, as has been mentioned, is the Queen's and Lord Treasurer's Remembrancer. It's a fairly ancient office of state. It was combined into the joint QLTR in 1832. Before that, they were separate offices. And essentially, in the Scottish context, it exercises the Crown's first right of refusal on assets when there's no heir can be found, or where a company has been dissolved and that asset becomes bona vacantia. So although it is the ultimate heir, as I mentioned earlier, it doesn't take on other rights. So if a person dies while they're still a trustee, the QLTR doesn't take on the responsibilities of being a trustee. And essentially what it does with that land or property is it disposes of it or disclaims it. Now, disposal is the kind of conventional term. It just sells the property on the open market. And if there's a value to the Crown to doing so, that's what they'll do. And the proceeds of that get paid into the Scottish Consolidated Fund or the Scottish Government's main bank account. In the event that the land has no market value, if they speak to the council or the community at the time, then they will decide that if no one wants to take it on, they'll disclaim it. And that means the land is then totally ownerless. The Crown has given up its claim on it as well. And it's essentially free and available for whoever wants to try and take it on. So very briefly, there's a couple of mechanisms. So this is one that I find really interesting, partly because it's never been used before. But general vesting declarations can be applied to land or only land from dissolved companies. So you're required to have that QLTR disclaimer. But under Section 1021 of the Companies Act 2006, anyone with a relevant interest can make an application to the court, in this case the Sheriff Court, to make a vesting order to transfer that property, providing the Sheriff thinks that they do have a legitimate interest and it would be just to do so. Theoretically, the couple of cases that I know local authorities have considered this route, their legal officers were convinced that it would be theoretically instant. I mean, once the Sheriff makes his decision, that's it made. And it would be reasonably cheap for that as well. It would possibly be just a couple of £1,000s in legal and court fees. However, both the cases that I know that local authorities were taking forward, they never actually took to court. So as far as I'm aware, this legislation in nearly 15 years has never actually been tested in court. But it's something that's interesting and certainly worth keeping an eye on, because it would circumvent some of the issues that arise with prescriptive claimants. Which brings us to prescriptive claimants. So again, this requires the QLTR disclaimer. And then as Murray noted, you get your provisional title. You can register your provisional title with Registers of Scotland. And then there are a further 10 years of open, peaceable and uncontested, although uncontested is not the technical term, it is without judicial interference, occupation. And that's exercising the rights of the landowner. This can be a risky process, as there is not necessarily the interim security. Provisional deeds are provisional, and they won't be legally full until after that 10-year period. But at the same time, if it's a community group, it's hard to see that anyone would be trying to counterclaim it, particularly if it's an asset that doesn't have a particularly commercial value and has already been disclaimed by the QLTR because it didn't have a commercial or open market value. Nevertheless, 10 years as minimum is fairly time consuming, and the legal fees for this, as well as other fees, can be quite expensive, partly because there is the lack of knowledge, and it's not common practice for solicitors to be going down the prescriptive claimants routes and following these type of processes. So how can the Land Commission help? So certainly, I realize this has been a bit of a whirlwind, but we can help with guidance on the process. Essentially, this kind of presentation, you can go into more detail, and I'm sure there are, I know there are questions that have been asked in the Q&A that we can talk about later this afternoon. But also we can help where land is not ownerless. So a lot of the sites that cause people a lot of grief and anguish and communities would like to see used more productively are not necessarily ownerless. The ownership might be ambiguous, but once you can find the person behind it and who is responsible for it, that's somewhere where the Commission can definitely help. We have a series of good practice protocols. We encourage landowners to take note of them and to live up to their responsibilities under the Land Rights and Responsibility Statement. So even if you go through that process of identifying a piece of land and you do come to find a landowner, well, there is another option as well if you want to see, if the community wants to see that land in better shape and used more productively. So not just about ownerless land, but if you do get to that point, then the Commission can help in other ways as well. And thank you. So that's it. Looking forward to the questions.
Thanks, James. I'm sure you've seen there's a few questions coming in for you. So our last speaker today is Paul Harrington from Highlands and Islands Enterprise, who's worked with the two groups who've spoken today. So Paul's just going to talk us through his experience from an agency perspective in supporting those two communities. Over to you, Paul.
Many thanks, Lindsay, and welcome everybody, and many thanks for the invitation to speak later on, speak today. Okay, so ownerless introduction, ownerless land introduction. As Murray mentioned and Alison earlier, we supported several community groups over the last several years. We've had in the region of around about 6 or 7 inquiries regarding ownerless land, and we've been fortunate to support both Culduthel Woods and South Islay development. Some of the areas that we support community groups with in the community access team, that can be working across the high patch, as well as signposting to relevant organisations, or even working with public bodies or intermediaries to come to some kind of route to potential ownership. And we're also been providing some financial support on a case-by-case basis, and that's only, I'll reiterate, that's only within the high area. As mentioned, many thanks for the comments, Alison and Murray. We worked with South Islay developments in the early days. And we supported them with some legal fees to do the exploratory work around prescriptive claimants and solicitor fees. And SLF were able to support them through a stage 1 and eventual stage 2 application, and they purchased, as Alison said, through the QLTR, from the QLTR with Scottish Land Fund monies. Culduthel Woods Group, slightly different, and as Murray said, we support them with some legal fees to go down the prescriptive claimant route. One that's not here today is about restoration. That's the Milton Community Woodland Trust near Kildare, adjacent to Kildare, just north of Invergordon, where a community group was looking to acquire the woodland area that from an organisation that had been dissolved and struck off. There was 1 or 2 members of that original community organisation still alive, and were able to take part in that process. And the Milton Community Woodland Trust are now going through a restoration process, and we signposted them to the likes of community ownership support services and other agencies to regards fundraising, because there are fees involved with the restoration process, including late penalty fees and so on. And more recently, in the last couple of weeks, we've been communicating with a group in the North Sutherland area who are looking to explore a route to ownership, and it looks again that that particular asset they're interested in is actually ownerless. Okay, that's a very, very, very brief overview of what we've been doing over the last sort of couple of years with regards to ownerless land. And I must say, and colleagues across the high area commenting that we've never seen so much interest and inquiries coming forward regarding ownerless land, whereas in the past, they're probably once in a blue moon or thereabouts. Okay, I'm conscious of time, so I will finish that there and allow lots of questions to be asked, and hopefully we're able to support where we can. Thank you very much.
Thanks, Paul. I think it sounds like South Isle Development and Culduthel Woods are quite lucky to be in the Highlands and Islands Enterprise area, because we've been able to give them support. It might be more difficult for communities in other parts of Scotland to go through this process. I can see that we've got a lot of questions in from the audience. I think we'll just go straight to questions. I've got a few questions of my own, which I will ask at the end, but it looks like there's quite a lot of interest in your talks today, so I'm just going to get going on the questions, if that's okay. I think the first question is maybe one for you, James. Does the Land Commission think there's an easier process in the QLTR route? But is this something the Land Commission is looking at? Because if you were designing a process from scratch, you probably wouldn't design this one. So is it something the Land Commission is looking to change in the future?
So certainly, I mean, I think that the last point that hits the nail on the head. If this was designed from scratch, it's been fairly badly designed. So it is something that that we have looked at, I mean, the QLTR in a legal context plays a vital function of being able to potentially bring ownerless land back into productive use. Because of the way it's set up at the moment, it's not, it was set up in the 19th century. So there's no kind of cognizance of community empowerment or, any of the kind of things that have developed in Scotland over the last 20 or 30 years. So yes, I think, legally the function is sound, but the processes that go around it, the way the QLTR assesses the value of assets purely on a kind of financial basis has been problematic in the past, and that could be something that could be changed relatively quickly. In terms of the wider scope, I think, once you take into account that there are more than financial benefits to any given asset, then that opens up more route for disposals of valuable assets to communities to go down that, which is a simple conveyancing process, the same as any other land transfer. I think the issue arises when you get to disclaimers, and there's one case in particular, which I think is Drummore Pier in Argyll, or no, it's not Argyll, it's in Dumfries, or Galloway even, right at the southwest end of Scotland, where the pier itself was owned by a company, and there was an accident, someone fell and injured themselves quite badly, and then had a claim against the company. The company couldn't afford to pay that claim, and went bust, so they dissolved themselves. But that claim hung over that piece of that land, and for anyone that was to then purchase that, they would have to satisfy that claim. What the QLTR disclaimer does is it removes all previous claims over a piece of land. So if a community is looking at an asset that has something like an overhanging mortgage or a claim against it of that nature, that could be very off-putting for the community to take on, because at day one, you're going to have someone chasing you for potentially a large sum of money. The disclaimer in that sense as a legal tool is very useful, because it removes all previous encumbrances and allows the community to take that title totally free, albeit after 10 years and after that risky process. So if there was a way to speed up the prescriptive claimants process and streamline that and make it much simpler, I think that's probably the area where we could do the most to really help communities and bring land back into productive use in a much more timely fashion.
Thanks, James. I'm going to stay with you because there's a couple of more questions that I think you might be able to answer. Can QLTR refuse to get involved? What is their obligation when it comes to ownerless land?
So the QLTR has to be sure that the land is ownerless. So as I mentioned in my presentation, that you can't just go straight to the QLTR. Otherwise, they will just say, well, what evidence have you got? And if you don't produce any evidence, they'll just turn you away. So you really do have to do the work beforehand of trying to find the title deeds, trying to trace any existing owners that might be around or any heirs that might be about. And even engaging the services of a professional searcher. I mean, that's something that QLTR will look very favorably on, and that will help speed up any kind of request that goes to them. So they can't outright refuse to investigate things, but they can question the evidence base. If it's a very flimsy or non-existent evidence base, they will say, okay, but can you go in and have a look and come back with a bit of a case? But ostensibly, if you come to them with a good case, they will look at it. The only thing to be aware of is if they then decide that the asset or the land in question is genuinely bona vacantia, is genuinely ownerless and theirs to deal with, that starts a 3-year timer. And at the end of that 3 years, they have to either have disposed of that land or disclaimed it. So there is perhaps a note of caution there for communities who do assemble that evidence, is if it does go to the QLTR, they agree with the position that this land is indeed ownerless and available for them to deal with. Is the community going to be ready to take ownership in less than 3 years? Are the processes in place? Are the funds kind of lined up as necessary? Because if they're not, after that 3-year period, the QLTR is legally bound to either put that property on the open market or to disclaim it. So perhaps a wee note of caution there.
And another question on QLTR, as our QLTR expert today. What's the decision-making process between choosing whether the prescriptive title route is the one to go down or going through QLTR? So I think we've had one of each example today. Is that effectively down to QLTR to make that decision, or is there a discussion to be had?
So there is very much a discussion to be had. I mean, the QLTR, as I said, is the ultimate arbiter of when land is ownerless and when it isn't. And if it decides that land is ownerless, it then makes the decision as to whether to dispose of it for value, as in kind of Alison's case in South Islay, or whether to disclaim it, as is what's happened in Culduthel Woods, where they perceive that there's no value. Now, there is a conversation to be had, because I remember when colleagues at HIE first got in touch with me about the South Islay one, I spoke to the QLTR, and their initial response was, oh, this looks like a case of trustees, so I'm sorry, we can't help. That turns out not to be the case after kind of tweaking and discussion behind the scenes and kind of a bit of prodding. It's like, can you have a look at this, think about it slightly differently? So there is definitely a negotiation to be had. And the QLTR, they're a small team within government, but they are really nice people, and they really do try hard to make a difference. They are perhaps a bit neglected in terms of kind of Scottish government and kind of their role in kind of the land market, but they are definitely there. They're very approachable when you get to that stage, and have a conversation by all means, and see if you can find an alternative way through, because they'll probably be very happy to have that discussion.
Okay, thanks, James. We've got a question for you now, Murray. In your opinion, do you think the long time scale moving forward has been as a result of COVID? Has that affected it, or do you think it would have been a really long time scale anyway?
No, I don't think our timescales have been affected by COVID at all. And in some ways, it's been, we've been able to work on these things in the background, and the clock's been ticking away, and we've not been able to do many other things anyway. So we've got on and done work on preparing our management plan for the woods, etc. But no, I have to say, I don't think COVID's interrupted us at all. I mean, sometimes it was just clocks ticking for procedural processes, so the clock couldn't start ticking until we had resolved through our minutes of our meetings to directly decide to take ownership of the land, and that was when the clock started ticking for the 1 year of our intent to acquire the land and to effectively occupy it. So that year would have passed just the same speed, whether or not COVID was taking place or not. So no, I don't really think that's been an issue.
Thanks, Murray. I have a question from Toya, which is definitely not a stupid question, because it is quite a pertinent one. If you have a piece of land that might be ownerless, what would you be searching for? Particularly, how do you refer to the land, get its name? And I know that's something we come across a lot at Community Land Scotland when communities are looking to buy areas of land rather than buildings that have addresses. It does make it a bit more complicated. James, would you be happy to answer that one?
Yeah, so I think this is where the ScotList system that's held by Registers of Scotland comes in really useful, because it's a map-based system. So you can go onto the Registers of Scotland website. I think ScotList actually has its own website, and then you don't need the address, because you can just zoom in on the map and find the area of land that you're interested in. If you're lucky, there'll be a kind of grayed out area, because it will have a land register title. You can click on, and then if the ownership details aren't there, you can buy the full title for £3. So for an investment for a community, that's probably reasonable. If, however, there isn't a modern land register title there will be a record somewhere on the Sasines, which is the kind of the paper record that dates back to the 17th century. That is potentially more complex and more expensive, because it's not a digital map-based register. But you can ask the staff at Registers of Scotland to look through that for you, and their archivists will look through it and see if they can kind of find the ownership for that. But that is lengthier, and it is potentially more expensive depending on how complicated the title is. So I would definitely start with ScotList, because it's an easy map-based system. If you know which piece of land you want to find, if you can find the title from that, then like I say, you can buy it for £3 and find out who owns it. Otherwise, you're probably into Sasines, and that gets much more potentially complicated.
Thanks, James. I think Paul wants to come in.
I just want to thanks, Lindsay. Just want to add to that what James just said. If you go onto the Register of Scotland website, they'll tell you what information that they require for you to carry out a search, and that includes a short map to scale and a brief description of the property or the asset.
Thanks, Paul. Murray, do you want to say something?
Sorry, just a related question. When the land registers complete? Registers of Scotland are currently working on that. And did I say it was due to be complete 2024, 2025? Will that show automatically as a class of land that is ownerless? Because that would be extremely helpful to community bodies just to have that clarity, that proactively showing that land to be ownerless.
So yes, and that's one of the that's one of the issues that is quite worrying colleagues in the QLTR, is although at the moment the land register is probably slightly behind. All public land was supposed to be registered this year. That's probably not likely to happen. So whether the land register would be fully complete in another 3 or 4 years' time is unlikely. But absolutely, at the point that everyone who currently owns land has registered what they believe to be their titles and have been approved by the keeper, anything that is left over is ownerless, and then is up for grabs for whoever can move fastest, essentially.
So
Just ask a follow-up question. So, Murray, do you want to say something?
I was just going to say, Lindsay, this is going to be a growth area, so your seminar is extremely timely.
And I just wanted to ask James a quick question on the back of that. Like, as you know, the way I passed my time is reading the Land Reform Review Group publication from a few years ago, and I was looking at their section on ownerless land, and they were kind of saying that some of the land which might on the surface appear ownerless might be a historical form of commons. You know, do you know if that's kind of panned out, and is that something the Land Commission is looking at as well?
So it's certainly something we're aware of. In terms of rural commons, they're much more difficult to pin down. Because their recording is almost non-existent. In terms of common good land in the former boroughs, that tends to be better recorded, and there is some legislation there, although we are seeking to work to reform that to make kind of common good assets more community assets rather than just things that are managed by councils. But I think, yeah, I mean, there could well be areas of land that are historic rural commons. I think particularly in the borders, there's probably a good idea of where that land might be, but the record keeping for that is almost non-existent. So they may well appear as big gaps in the completed land register in due time, and I guess if they're large enough, they may be quite valuable. So there could well be a need to have a think carefully about how the system of kind of prescriptive claimants works at the moment. So it's not a kind of mad scramble by communities and individuals and business and everyone just trying to essentially grab free land.
Looking forward to that. I've got an interesting question for you here, James. Can the Land Commission apply rights and responsibilities respectively if land has already been sold, or is it too late? I don't think we have any powers to apply things retrospectively. So I think once land is sold, it's up to the current owner to live up to the expectations. So land ownership comes with rights, but it also comes with responsibilities. I don't think there's a mechanism for us to be able to enforce that retrospectively, but anyone, and I mean absolutely anyone that is a landowner currently or is taking on land in the future should be living up to the principles of land rights and responsibility statement, and essentially be using it, following the kind of the protocols that we publish that demonstrate best practice in land ownership. The next question is, what happens if ownership is lost or it's uncertain through unmapped title deeds? So if someone, that seems to be less common now than it used to be, is that right? But I'm guessing it still happens.
Yeah, so it does happen a bit. It is less common with personal ownership because people are usually better, or more recently have been better at writing wills and passing their estates on to, if they don't have children, to at least nephews and nieces or cousins and that sort of thing. So that is rare. It does still happen. I know the QLTR have dealt with cases of crofts in Shetland, I think, where there tends to be a kind of more owner-occupied crofts rather than tenanted ones. And they have an indication that people's families migrated to Australia, South Africa, at the turn of the 20th century, and have absolutely no idea whether there's legitimate family, legitimate heir still alive and let alone interested. So there is still a bit of that, but I think it is probably much rarer than it used to be. I mean, ultimately, it's a decision for the QLTR to make. If they're confident that there is no heir that's going to come forward, they will then acquire the land on behalf of the Crown and then deal with it as they see fit. but where there is a risk or where they believe there's a genuine heir out there waiting, they will probably tend to be more cautious and hold off taking any action. So again, that's possibly passing it back to the community to do a bit more digging.
Thank you. A question for you, Paul. What do you think is leading to the increase in interest in this area from communities?
Thanks for the question. I think it's we've certainly seen an increase with legislation over the last sort of 10, 15 years, and the power that communities have with that. And it's also empowerment of communities. Communities taking, realizing that there's some good for community benefit. There's additionality that the community can gain from acquiring the assets. So there's a lot more awareness around nowadays than what there was previously. So community empowerment actually played a big part in that. Communities are much more, like I said, much more aware and where they can go to for advice and guidance, particularly through the membership organisations such as Community Land Scotland, and not forgetting DTAS and Community Woodlands Association, 2 or 3 that spring to mind. But there's a lot more communities out there wanting to do something with a piece of land, whether it be vacant derelict land, whether it be sustainable development, or even community right to buy processes, all have their own mechanisms and legislation to support them. So yeah, it's the more and more awareness that's out there, the more and more we'll see communities coming forward, and we're expecting that to increase over the coming years.
Thanks, Paul. Murray, you want to say something?
It's just, sorry, it's another question from me, but I think it's related to what Paul was saying. I just wonder, given the increased interest, if it would be possible to tweak the procedures in some way. Maybe this is a question for James, so that community bodies at the moment are having to go through the same process as a private individual or a commercial company would, and yet we're acting in the wider community interest, and we've gone through a lot of work to establish charities and already. Would it not be possible to have some kind of accelerated or streamlined process for community bodies who want to try and go through this route? And and would it be possible to do that in a way that doesn't require legislation? Because obviously that's going to take a while. But with goodwill and political support, I would hope that Registers of Scotland and QLTR might be persuaded to, I don't know, lighten the administrative burden in some way, if it's a community body that's interested.
So I would certainly hope so. I think one of the things I mentioned is when the QLTR was set up in 1832, the current ideas around community empowerment were would have been totally alien. So there was never any consideration of that. But I think in the modern age, having that negotiation with the QLTR, they are open to those sorts of discussions, I think now, and they are good people to work with if you find yourself having to work with them. Registers of Scotland are maybe slightly more difficult. They are more technical. There's a lot more legal burden on them because the titles that they register are legally binding, that they have to be reliable in that sense. So there is perhaps less flexibility around what they can do in terms of negotiating with communities on speeding up processes and that type of thing. But I think there's certainly with the QLTR, there's a lot that could be achieved with shifting policies away from having a disposal policy that essentially recognizes highest value being highest price, to looking at a wider, kind of broader base of value of kind of amenity and effect on the community and all the rest of it. That's certainly a negotiation that can be had right now. And I think policy changes could come in relatively swiftly to do that. I think prescriptive claimants is, the legislation for that was updated, I think, in 2012. So it's unlikely that government or parliament would want to revisit that anytime soon. But there may be other routes, and I think particularly when it comes to corporate property, the use of vesting orders is something that hasn't been used at all, and is potentially something that could be used. But it's perhaps one of those things that's even less known than even the concept of ownerless land. And as I say, I'm not aware of any cases that have gone through the courts, so no one really knows enough about it. There's no route to follow at the moment. We need some trail breakers.
And the community right to buy doesn't apply to land that's held by the QLTR, does it? Because it's not technically owned. So that's another complication. I think South Island development is a good example of where a community is effectively buying back land that was originally in a form of community ownership. Alison, what was that experience like? Were people kind of accepting of the fact that they had to buy back land again, or what kind of dynamic did that create?
I think it was confusing. I think that was probably one of the first instances, I think, because it was, I think, confusing and infuriated. I think they were, because we couldn't prove it, and I think because it was just a glitch in the legal terms, I think, and it was just, I think the community still is. I don't think they're entirely happy with how we had to go around to get full title back. And as a board, I know that the directors are not entirely happy either, but it was a means to an end, I suppose, to get things moving forward. But we couldn't move forward with any of the community's aspirations without owning the land. So it was something that had to be done to get the developments moving forward. Otherwise, we would be stuck with not being able to go for funding and consistently having to find other solutions of funding it, which all boils down to owning the land. I think there was always that final tick box, isn't there, when you go into an application, do you own the land? No, and then you're like, no, we can't do that. So it's that, I think that was the key part that really triggered the community to, I suppose, get behind it and support, although they weren't entirely happy with it. That was why. I think, as James said earlier on, and I think it's been highlighted, I think the communications with the QLTR initially were quite slow, and I think we weren't getting the right answers initially. And I think it is consistently re-asking and finding a different avenue to ask the questions. And I think all the support that we got from all the officers and development officers, I think really helped, because it just helped us find a different angle to be able to approach them. And I think having all the different angles that everybody else has, they were detailed and high, and being able to have these chats behind the scenes for us and show their support and ask the questions and get more advice from it really did help it. I think without that, we would probably still be trying to get somewhere. I don't think we would have got as far as we did if we didn't have the support and advice behind us.
Thanks, Alison. I've got a couple of questions on your specialist subject, James, of vesting orders. And has there been any use yet, or is it just something that is kind of there with potential? And what evidence might be required to go through that process?
So this is one of my frustrations, is that it hasn't been used, the legislation. The closest it got was Perth and Kinross Council got as far as lodging an application to the sheriff for the Strathern Hotel in Crieff, but ultimately the owner of the dissolved company that owned that hotel restored that company and then came to a negotiated settlement with Perth and Kinross Council. So the sheriff never had to make his decision. There was another case in I think on Bute in Rothesay, where our Argyll and Bute Council had done a lot of the background work and had put together the evidence for going to the sheriff, but ultimately the councillors decided that actually the council didn't really want to take ownership of the site in question. So that again never made it in front of the sheriff. So I mean, the answer to that is I couldn't honestly say what sort of things the sheriff would be looking for, because no sheriff has ever been asked, or likewise has never even asked what evidence they'd like to see, or demanded it of an applicant. So I think in terms of both councils, so both Perth and Kinross and Argyll and Bute, they had to do kind of maintenance work under their statutory powers on the sites in question, so they could demonstrate that they had spent thousands of pounds making buildings safe or that kind of thing. What a community group or someone else would have to do to prove a legitimate and just interest in the site, I genuinely don't know, but hopefully someone will try in the near future.
A question from Toya about when the land register is complete and all the remaining land becomes ownerless, how do we find out which land is ownerless the fastest? I'm thinking probably want to start on the detective work now to figure out what land is ownerless in your area. And I think that's often easier in rural areas where people do tend to know the history of land than it maybe is in urban areas. Paul, do you want to say something?
Yeah, For those communities in the high area, they can always contact the local community assets team member, development manager, who will be able to explore different or the possible routes to ownership that may be there. James mentioned earlier on, obviously the vesting side of things. We've had company restoration through the Companies Act and QLTR, and also the Registers of Scotland prescriptive claimant process. But there's also local authorities may consider applying compulsory purchase order, or it doesn't have to be a local authority. It can be a public body with compulsory purchase powers, who may, which was the case for a group in Argyll and Bute on Rothsay, where the local authority acquired the asset through compulsory purchase rather than going down a long and protracted route to demolish the assets for affordable housing. So there's always, in the high area, contact your local development officer in community assets, and they'll be able to provide some advice and guidance on which way to go.
I'd say as well that ownerless land, I mean, sometimes it's a blight on communities, which is why some communities want to do it. But I think being aware that ownerless land, whether it's a building or land, might have been left for a long time and might need quite a lot of investment as well. And as a community, have to think about that as well if you're looking to take on that kind of land. I think what done in Culduthel has been a brave move to go forward with this as your kind of first acquisition. It's really impressive what you've been able to do going through that process, and it's also kind of highlights what happens when community councils kind of highlight these problems and they don't have a way of moving forward. That often leads to the setting up of community land organisations. Toy is asking about getting into good position to advance. I think contact any of our organisations. I would say about that. Scottish Land Commission, Highlands and Islands Enterprise, ourselves, Development Trust Association Scotland. We all speak to each other. So if you come to any of us for support and we don't think we're the right body to help, we'll put you in touch with the right people who are. It's a friendly environment, community land world. The last question I think is going to be back to you again, James. Asking about how much influence funders have about the prescriptive title route or QLTR. Will funders be more nervous about funding major development on titles acquired via the prescriptive route as opposed to a cleaner title from QLTR? You might have something to say on that as well, Murray, but I'll ask you first, James.
So I suspect they might do. Obviously the prescriptive claimants route doesn't grant full title until the end of that 10-year period. So there is always a risk that a genuine heir or owner could come out of the woodwork at that point and say, kind of, "Oi, what do you think you're doing? This is my land. Here's my title." It's highly unlikely, but if you are looking potentially for significant funding, that might be something that's off-putting. I suspect Paul might be in a better place to talk about funding than I am, but I mean, the prescriptive claimants route is a long one, and there are definitely risks there to be aware of.
Thanks very much, James. Yeah, just to add to Murray's situation at Culduthel Woods, they're going through that prescriptive planning process. Yes, a year's possession without judicial review and so on, but it is a 10-year process. One of the main funder for land assets and building assets in the country is a Scottish Land Fund. However, Scottish Land Fund requires a willing seller, and if the seller can't be identified, then they need to explore a different potential route to ownership. And if they are able to identify the owner who will be a willing seller, then it wouldn't be an ownerless land issue. So it's about understanding what the funder criteria is. And unfortunately, SLF can't support that. Added to that is the fact that Scottish Land Fund has a monitoring period of up to 5 years only, whereas a prescriptive claimant process is up to 10 years.
Thanks, Paul. Murray, is there anything that you'd like to say on that?
Well, it's been a fascinating discussion, and there's maybe a few points for Community Land Scotland to pick up there and press the relevant public agencies on, because that situation you were describing there with the Scottish Land Fund there, Paul, it sounds to me like you're disadvantaged if you're not in the high area potentially, because you wouldn't be able to get the support that you were able to give us. But also I would hope that going forward the Scottish Land Fund procedures were able to change so that it could cover the ownerless land situation and you were able to get that level of support. So yeah, happy to discuss that after the call.
I've just got one last question before we finish up. I was just wondering, you were talking about solicitors. I wondered, how difficult it is to find a solicitor that understands this whole area, because we know Community Land Scotland finding solicitors who understand the community right to buy process can be tricky. Is this even more challenging to find a solicitor who knows how it all works? You sound like you've got a solicitor who knows what they're talking about, Murray.
Well, yeah, I'd certainly be happy to recommend the solicitors we used. I mean, looking back through my plethora of emails, I saw that we were also offered support at a very early stage by the Scottish University Student Law Association. That's not quite the right acronym, but I'm sure there are very good solicitors out there that are willing to help. But again, Community Land Scotland, I'm sure, can play a really useful role, just putting people in touch informally and making offers of help.
Thanks, Murray. Is there anything anyone else wants to say from our panel before we finish up? Or are you all QLTR'd and Ownerless landed out? In that case, I will say thank you very much to our panel. It's been a really fascinating discussion this afternoon. I have certainly learned a lot from it. So thank you so much for taking time and putting together your presentations and coming along and speaking today. I also want to say thanks to Christina, my colleague, who's been doing all of the work on Zoom behind the scenes to keep the whole thing running, and Kerry, who did the preparation for the event. And lastly, thanks to the Scottish Government, which funds us to do a lot of these events, which I think communities find very useful. So thanks a lot to everyone today. As I said, this video will appear on our Vimeo site in a few days' time if you want to share it with anyone. Thank you.
Okay, thank you.
Thank you. Thank you all.